আমি গেছিলাম কনজিউমার কোর্টে, এখান থেকে আসছে একটু হাজিরাটা দিয়ে দিই এখন।
So there is a question of law involved. Mr. Binnu has raised 2 or 3 questions of law. They can be agitated and dealt with because it is a matter of the airport. He is in on the ground because of the fact that he was there. Technically speaking, there
He had control over the area, physical control over the area.
but he remains in control, and I am the person trying to get in. So this is because it's a matter of public tenders, public money, it may have some significance. Plus, the airport is a very
Who is the effective respondent?
No.
No. You are the petitioner. No, you are the private respondent. The authority who is representing.
Airports Authority of India. Is there.
Where is she? Yes, when all of you want.
Any day.
How much time? A rough estimate.
But Binnu on one side and me on the other side. Forget about it.
Yes, that's the difficulty because to complete and the other things, subject to convenience, I'm marking this. I'm not fixing any date. Any day subject to convenience because next week I've fixed many matters because motions are to be given priority. So motions are to be given priority after the division make these motions. So after that, I'm also fixed one of the second appeal for hearing of Mrs. Nag. So was scheduled to be, yes, tomorrow. So I'm marking this, any day subject to convenience, both of you can come or all of you. I cannot say both of you.
Difficult because everyone coming at the same time is what I appeal may not be possible. If your lordship fixes a date, we cannot plan for it accordingly. If it is not taken on that.
All right, so mention this on, may not be you through your juniors on Monday. So that's subject to convenience. I will consider whether a date can be fixed.
My second mentioning is item number 55.
55.
55. This is a matter with regard to police inaction. We're talking about the. Oh, sorry, Mr. Shumik Karmakar is there for the state.
Police inaction.
My lord, there is a rather serious situation because there was a communal riot of all things in ambulance of the person. And that has created a big problem in Delhi. Over that, some FIRs were registered, but action was not being taken because there was a politicizing of the matter. Thereafter, this honorable court took up the matter and has been supervising and monitoring the investigation from time to time. As of now, the charge sheet, what happens is every time we come to court, a few more sections are added, a few more people are added. It's going. Now they have said they have a charge sheet ready. Court was not satisfied. Court has handed over the matter to NHRC to come and have a look at what is going on. NHRC was asked to file a report. NHRC has filed a report which is bland to say the least. We were asked to respond, we responded, but the whole matter is now hanging fire because the court has to pass on it.
Item number 55.
55. But if I could get some priority.
All
here,
right.
I
So
didn't
mention
consider
this,
short-
next week I will consider this fixing these
Right.
matters.
And third is item number 67,
Yes,
which is a matter involving quarries.
yes.
Essentially, what has happened here is that.
Mr. Chakraborty is appearing.
What has happened here is this matter has been pending for a year or so. It has a bearing on industries, on the road, on various things here because it is connected with allotment of quarries. What has happened is that this man had a quarry allotted to him 2 years back. He couldn't operate it for certain reasons, he was not permitted. Now, there were two in the same situation, both came before the court. One got an order of mandamus saying operate the quarry. I got an order saying consider.
Yes.
So one person.
Not with
operated the-
regard to the self-same query.
No, two separate quarries, two separate petitioners,
Yes.
separate writ petitions.
Yes.
Now, that man operated the quarry, made his money and went. I got considered and rejected. So I came to the court. Court said.
So you are
consider.
challenging the reasoned order.
No, I'm not. Actually, there were two more rounds of litigation. Then this court finally sent the matter to the chief secretary, saying, Chief Secretary, you please decide. Chief
Yes.
Secretary decided in my favor and referred the matter to the Deputy Commissioner to do the need. Deputy Commissioner.
That is the only consequential part.
Deputy Commissioner goes against the Chief Secretary's order, saying it's not possible for these reasons. So now I've challenged that decision, where I'm showing why it is possible.
Whether he can go or he can take a view
No.
contrary to the,
That is one part of it, and there are other parts also on law. Now, at this stage, when the matter affidavits, everything, hearing and all is done, I must make this in the interest of fairness, this submission. Matter came up before a coordinate bench. Coordinate bench heard me, everything was fine. And then suddenly the question arose, is there an alternative remedy? Now, at a belated stage of final hearing, the question has arisen, and now we have found. I
whether
think
at
is
this
a
stage you
proper
should be relegated to the alternative remedy or not.
This will be given some priority.
All right. These three items, I'm making a note of this. Make a note of this. Next Monday, I will consider fixing this.
Monday, I would mention this.
I'm last in the queue. I'm last in the queue.
I am also there, sir.
There is one matter item number 30.
मंडे तो
It's
हमारे
the second
एक
appeal
के
of
तो
2018. Madam's appeal is of 2022.
You are not there. Jaipal, you are not there.
But after, immediately after.
Jaipal, yes, but the question would be
No, the
when
two
to
questions have been formulated by the division bench.
second appeals, 1, 2, and 3, not more than that. But the question is to, it is to be hard. That is the difficulty, and the time constraint is the factor. Yes, yes, I will definitely. Who is opposing you? All right. So I will consider that if time permits, subject to both of you coming, I will accommodate.
My lord, that while fixing my lord that matter, that query, while fixing that query matter, my
I'm
lord.
not fixed.
No, my only request is my lord, 6th and 7th, I'm in some personal, I have to go back to Kolkata because of some family issue, my lords.
6th and 7th.
6th first half, I'll be there for the division bench, but after that I have to go 7th, my lords, I'm not available. There is a personal problem. I have to go to Calcutta. 8th, I'm available. So only 7th, I may be.
It takes us to the end of this.
Before
circuit,
6th
that's
is, my lords, I have personal, only one day, my lords, I have personal problem, family problem. I have to go
No,
to
no,
Kolkata.
That's okay.
Only
6th
7th.
and 7th, you have some problem.
Yes, my lord. Any day before.
5th, you are available.
Yes, yes,
So
rest
if
I'm available.
possible, if possible, subject to the convenience, I will.
My lord,
consider.
no, other than that, I'm available, my lord. So
Or how much time it will take? Rough estimate.
some time, Mr. Kabir will argue first, my lord. I have to only respond.
All right.
Is order whereby my application for.
चला जाता हूँ, करके mentioning करके।
Was rejected by.
Civil division में
Start is also the-
Item 38.
It's pending my lord problem.
Mrs. Nag is opposing you.
I have informed her. But you know, perhaps I'm not.
All right. So mention in the presence of Mrs. Nag so that if yes, for inclusion today. File the slip. Check it up that today was the date. If that is so, under what heading? Hearing or motion? Read petition. Check up if it is, if a direction was there, list it tomorrow. Yes, call the list.
Now for private customer.
Who is for the petitioner? Yes.
I purchased a piece of land
You
and
purchased?
as per the agreement, I purchased the land
Yes.
from the private respondent and I made my construction. I'm residing from the
Who is
date of
for the
agreement.
authority? Who is-
I'm applying for office.
What has been done by the private respondent during pendency of the civil suits are also pending. Approach to the Tehsildar for eviction against me. Tehsildar passed an ex parte order against me. They file a writ petition before this court to execute the order by Tehsildar. So I approached to the Tehsildar because ex parte order was passed by him. I initiated a proceeding before the Tehsildar and Tehsildar is not taking any steps. The proceeding has to be disclosed.
No, it's not so easy. Several things, my lord, with sitting with my lord Justice Ashish Kumar Chakraborty had occasion to deal with an mandamus appeal relating to the same. I was the writ petitioner. Order was passed. The Tehsildar was directed to implement the order. That was carried in appeal before my lord. Some interim protection was given. The order was set aside. It was remanded back to writ court. Writ court.
I heard this matter.
Yes, with Justice Ashish Kumar, I can place that order, Your Worship. Lord, kindly come to
No, that
page.
is serial number.
Page. No, it's relating to the same writ, Your Worship. Page. There
It
are
is
3,
also
4
mentioned
paginations,
that
my lord.
matter is also
Yes,
fixed
yes.
today.
Page 50, 51 and 52.
51.
Not there are 3 pagination at the top 103, then page 50.
All right, top, you mentioned the top.
103, my lord.
Yes, 103,
My lord would see the last 105.
105.
This was an interim protection which my lord has granted, sitting division name, Lordship.
Yes.
And then, Lordship, ultimately at page 106, the mandamus appeal was allowed, the writ court's order was set aside, the matter was remanded back to the writ court. Then
Yes.
again the writ was dismissed. Again mandamus appeal was preferred. It was revived, the writ petition was revived by setting aside the writ. Now writ is pending. Now during the pendency, there are 3, 4 orders being passed. Now, if any order is passed, even if it's an order in simpliciter, directing the Tehsildar to consider, that would tantamount to sitting out those orders. Because the writ court is the seizing of the matter, whether the order can be implemented or not.
Where is the writ petition pending?
My lord, it is before this court. I can give the number. I can give the number. My lord.
This is in the list.
Yes,
in the
yes,
list,
in the
Your
list only. I'll
That
just
is in
read
the
that.
Let this be heard along with
Yes,
that.
yes,
Your
that
Lord.
can be done. That can be done.
Let this, what is the item number?
I'm just not, it's not been listed.
No, in the list, is in the list.
Number.
What is the item number?
Just one.
Just
15, my lord. Item number 15.
15.
Yes, my lord.
That is your writ petition.
My
Yes,
writ
Your
petition.
He is the private respondent
There,
in that.
yes.
I am private respondent in that. Which is order I sought to be recalled by the Tehsildar
Let
is
this-
in that.
Item number 1. Let this writ petition be heard along with WPA 179 of 2019.
Lord.
All right.
Yes.
If today it is called, today it can
Yes,
be
yes,
also
yes,
taken up.
my lord.
Yes, next.
I'm for the writ petition.
Yes.
Same for respondent number 1.
I'm for the respondent number 2, my lord.
Yes.
Last order only kindly receive once, my lord. Second, directives were given. I have been granted interim protection. While giving interim protection, certain liberty has been granted to my client to carry out certain repairs. Once that is done within the time limit so prescribed by this court, the council would make an inspection and would submit a report.
The matter is fixed on 5th on Monday.
Matter fixed on?
5th of February. Lord, we have to conduct the inspection on
No, no.
2nd.
Matter is fixed today.
No, Lord, that's what.
Oh, there was a
Earlier
direction.
direction,
Yes,
yes,
yes, yes.
They have to do the repair within today, my lord, and we have to conduct inspection tomorrow and report has to be filed at that extent. The matter is fixed on 5th of February.
Yes. The inspection have you made?
But today we are going to inspect because tomorrow is the last date for the inspection. On 2nd it is given.
Second.
2nd.
Mr. Japal, you have undertaken the repairing
I'm
work.
told, you know, certain minor work making the premises
You have
habitable.
done
It
that.
has been done so.
Acha.
It has
Alright.
been done so.
Come. Mr. Jaipal, learned advocate representing the petitioner submits that pursuant to the order dated January 18, 2024, the petitioner 18, January 18, 2024, the petitioner had already undertaken the repair and renovation works in order to make the premises safe for human habitation. Yes, Mr. Jaipal, that is the
Yes,
paragraph. The learned advocate appearing for the, who will conduct the inspection?
Respondent number 2.
The learned advocate appearing for the respondent number 2 submits that an inspection pursuant to the order dated January 18, 2024 shall be carried out on 2nd of February 2024. Stop. List this matter on 5th of February 2024 as directed by order dated January 18, 2024.
Blair.
Yes, call the next matter.
WPA 49 or 20.
I'm there for the repetition.
Yes.
And I am for respondent number 1, 2, 3, my lordship.
Lord, what has happened? Lord, a civil court granted an eviction decree.
Civil court granted an
Eviction
eviction
decree.
degree.
Lordship,
You are for the,
I am the third party who has taken out an application under Order 21, Rule 97 in the execution process. It's
Yes.
pending.
yes,
And my possession has been protected by this honorable court. I'll show that on.
yes. Now what do you want here?
Tahsildar, Lordship, under the garb of demarcation. Now, normally demarcation is done just to inspect the property and to ascertain the four corners and to inform the party concerned. Under the garb of demarcation, the decree holder approached the Tahsildar. He, without issuing any notice, trying to dispossess me from the property in question. I have come up with this writ application.
Have you implemented the decree holder?
Just let me see. If it's not, I'll do it.
Tulsi Adhikari?
Yes, he's there. A service has been done. I'll file the affidavit of service.
Where is the affidavit?
I'll give it to you. Just one second. Let me see.
Yes, what is your instruction?
My lordship, here the remedies available before the civil court.
No.
The approach-
Remedy is available before the civil court is with regard to the inter parties, private parties.
Yes, my lordship.
But what business you have to demarcate and to dispossess?
My lord, we are now, at no point of time we have issued any notice, my lordship, and he has not at
Show
all
us that
annexed any
notice.
notice.
Without due, no, I have not been given a notice.
No, my lordship.
Specific case is, no, normally demarcation is done issuing a notice. My specific case is that no notice.
I've taken instruction,
Without
my
due process
lordship,
of
he
law
never.
means, my lordship, no notice is given. They would come and demarcate the land and I would be thrown out from the suit property.
My lordship, that is not the
If
procedure
they are
for
saying,
doing a
my lordship, that they
demarcation,
will
my
not
lordship.
disturb my possession under the garb of demarcation, I have no problem. They can do
You are
the
not
demarcation.
disturbing, I am recording your
Yes.
submission.
My lordship, normally in the demarcation proceeding, we will issue the notice, but here in order to get.
No,
a stay
what is
order-
your instruction? Are you doing anything or you are not?
No, my lord, we are not doing it.
So I am recording your submission.
There's one indulgence. The private respondent service, I can file it tomorrow only, my lordship. I have not filed the affidavit.
Then I am keeping it tomorrow.
I'll file it tomorrow. I'll file it. I'll file it.
Not today, next.
Problem, my lord.
Item 4, WPA 49 or 2023.
My lords, I have serious objection, my lord, to the maintainability, my lords, of this writ petition, my lords. I have
Yes.
gross abuse of process. My lords, I would like to, I have prepared a short note, my lords. In fact, the client has prepared. I'll just place that before your lordship. Email to person. And I'll place the documents one after the other. My lords will see the prayer in the writ petition. This is seeking a registration of Bepari Wooden Complex Sawmill in terms of wood-based industries establishment regulation guidelines and subsequent clarification. Now, there is an express bar to a writ petition or any relief being sought from any other court other than the Supreme Court in a particular proceedings. My lords, the first is 7th May 2022 order, my lord, to 2002 order. In the case of T.N. Godavarman, my lord will see straight away, my lords will have the point number 8 and 10, which is at page internal page 8. Kindly have internal page 8 of this internal page 8, my lords. The
Yes.
license, this is licenses of all the sawmills and wood-based industry shall not be renewed after 31st March 2003. This will not debar the authorities from cancelling licenses in accordance with law if there is no breach of the license committee by the licensees before that date. And serial number 10, Union of India, if it so adopts and thinks appropriate, may take steps for relocating the dislocated wooden industries in the main land area anywhere in India as long as it is not within vicinity of forest area. Henceforth, for meeting local requirements, it is only government sawmills which will operate.
Yes.
After this, my lords will see the second point. Department, with a letter dated 10th May 2002, intimated the petitioner to utilize existing stock of timber on or before 31st March 2003 and stating that license will not be renewed any further. Now,
Yes.
this is that letter. 10th May 2002. Kindly see the letter. I am directed to inform you that the Honorable Supreme Court in the above cited area order has observed as under. Ecology does not permit any kind of industrial activity for which wood is likely to be consumed. Therefore, licenses of wood-based industry shall stand cancelled, but will be permitted to exhaust as existing stock till 31st March 2003. The licenses of all the sawmills and wood-based industry shall not be renewed after 31st March 2003. This will not debar the authorities from cancelling licenses in accordance with law if there is no breach of the license committee by the licensees before that
So you
date.
have communicated this to the.
Yes, it is
citizen.
communicated. After that, the third point, my lord, is that the Andaman and the Nicobar Island Small Scale Wood Industries Association
Yes.
moved an application before the Honorable Supreme Court to modify the prayer in that.
So Mr. Chakraborty, only one thing that I think there's no, have you prayed for any interim order? There is no scope for any interim order.
He has
So
applied to the Supreme Court.
let them file an affidavit, because this you have to deal with this.
I'm not asking for any license at all. What he has said, this is the old story. Now they have to proceed in terms of the guidelines of 2016.
No.
In terms of the 2016 guidelines,
Yes.
a clarification has been issued subsequently, and clarification is at, I don't know.
No, so you are pressing prayer C.
My lord, I am only pressing that I should be allowed to operate.
Yes. Prayer C you are pressing.
Yes.
So, so prayer C, so no interim order can be passed. According to that, Mr. Chakraborty has some objections. So let him file his affidavit.
I need to place one more order, my lord. Same relief has been already sought before Supreme Court and rejected. They have
All right,
to
so
approach
you
Supreme
take this point.
This is something entirely different.
All these points,
Well,
file your affidavits.
No, this is
Preliminary
entirely
objection-
different,
No, no, it's
you know.
not different.
All right,
No,
you
no.
take those, let him
No,
take
no.
it by, because there
I'm
is
not
no
coming
scope.
in the way.
There is
I'm
no
not
scope
coming
to-
in the way.
Yes.
But they should not make such kind of submissions.
No.
Which are totally.
No, I'm not, I'm only giving them liberty to file
And
affidavits.
my lord,
I'm not coming. in.
Because there is
them
no
file
scope to
affidavit.
pass any interim order at this.
well, point of maintainability may be kept
Yes,
open. my lord.
Yes.
All points. Ashun. After hearing the learned advocate for the petitioner, after hearing Mr. Lal, learned advocate for the petitioner, and Mr. Chakraborty,
I'm Rajendra Singh.
oh, sorry. After hearing Mr. Singh, learned advocate for the petitioner, and Mr. Chakraborty, learned advocate, representing the Andaman and Nicobar administration, and upon going through the reliefs claimed in this writ petition, this court finds that the dispute involved in this writ petition can be decided only upon exchange of affidavits. First up, considering the nature of the reliefs claimed, there is no scope to pass any interim order. First up, Mr. Chakraborty, learned advocate for the Andaman and Nicobar administration, raises an objection as to the maintainability of this writ petition on several grounds. First up, let affidavit in opposition be filed within
4 weeks.
4 weeks from date, semicolon, reply thereto, if any,
Within 1 week.
be filed within a week thereafter. The issue of maintainability of this writ petition is kept open. Let this matter appear after the period fixed for exchange of affidavit is over.
I may be given a liberty to mention also, my lord. That is
is
the
always-
problem which I normally face.
That is always there. Mr. Chakraborty, take back this
Mine.
because include that in your
Mine.
oppositions.
Obligement.
Yes, next.
I'm there for the repetition. Not the authorities.
I'm for the authorities, my lord, the director of transport, I'm filing my member of appearance.
Lord, this is the second time I'm before this court. In the first round, an order of the licensing authority cancelling my driving license has been challenged. Lord, certain allegations based on certain adverse reports were relied. Lord, mainly on the ground of principle of natural justice, the order was set aside, the matter was relegated. Again, an order was passed. I prefer an appeal, statutory appeal under the Motor Vehicle Act. The appellate court also did the same thing. Adverse material relied, no copies given, no even if I was not allowed to have an inspection. So this is the first ground to challenge the impugned order. Secondly, they have invoked section 19 of the Motor Vehicle Act.
You have a copy?
No, I'll just.
Acha, Motor Vehicles Act. Show me the impugned order once.
Lord, it's Lord kindly turns to the page 45, annexure P9.
Yes, page 45.
Annexure P9.
Yes.
This is by the
This
appellate
is
authority.
by the licensing
No,
authority.
by the appellate authority.
No, this is by the appellate
Appellate
authority.
authority. Licensing authorities order not would find.
All right, this is an apartments, I can take up the
My lord,
appellate
my
authority.
lord, my lord.
Yes.
Lord, my lord would find page 45 simply records what we have submitted. Whereas, my lord would find at the page 45.
Yes, yes, yes.
My lord, kindly
That is
turn-
the operating
my
part.
lord,
Decision
operating part, my lord would find at page 47, last paragraph.
Yes,
Whereas after hearing
yes, after hearing.
both the parties and careful consideration of all facts and circumstances of the case and provision under the Motor Vehicle Act 1988, the undersigned is of the considered view the appellant Sir Firdaus Ali had driven the STS bus second time in a drunken state when he was caught by traffic police at Bathu Basti under the influence of alcohol, putting the safety of passengers at grave risk. His culpability is aggravated by the fact that he had not intimated the department about the seizure of his license by traffic. Now,
So
therefore,
you are the driver of the.
STS. I've been terminated from the service on this count. That's a different aspect. That's under challenge.
Yes.
But so far as licensed party is concerned, my lord,
License affects you because you cannot.
drive any car,
Drive
any
any car.
vehicle. Lord, in this order, reports were used. Well, I'll show that. Lord would find page 45, third paragraph. Page 45, third paragraph, my lord would see.
Yes.
Whereas on receipt of report from DUSP traffic, my lord got it.
Yes.
Letter dated 25/2/2021 containing 7 cases of violation under 184, 185, which included the name of SM Firdaus Ali. The driving license of all the 7 license holders were suspended for 3 months on 3/3/2021.
Yes.
Then was this one more report, adverse report, which was used against me while taking the decision. It's at page 46 at the top. Whereas from the report of Deputy SP Traffic, it was observed that despite being disqualified from driving, Sri SM Firdaus Ali did not inform the matter for disqualification to the transport department and continued to drive public transport buses during the period of disqualification, thereby putting other road users as well as the passengers in serious danger. Now, there are several grounds I've raised. The first and foremost ground is when an adverse material is collected against me to take an adverse decision. Now, so the principle of natural justice demands, if it is a voluminous records inspection, report 2 pages report. And particularly in this case, there's a direction of this court. While remanding the matter earlier, they were directed, you give the report to me. That was not
Where is
done.
that?
My
Where is
lord.
that? Show me that.
Not page 27. 27. P5. Now I would find it at page 28, last paragraph. Thus, without going into the correctness of the order passed by the licensing authority, the order impugned is set aside on the ground of violation of principle of natural justice and also for violation of provisions of Rule 19(1)(f) of Motor Vehicle Act 1988. The order dated March 17, 21 is quashed. The authority is directed to hear the matter de novo upon granting an opportunity of hearing to the petitioner. The petitioner shall be allowed to inspect all records and reports that may be in the possession of the authority with regard to his conduct and the past proceeding held against him. The
Yes.
petitioner shall be entitled to file a written reversion in support of his.
So you are given liberty to inspect.
Inspect, it was not done in the present case. I've taken a specific stand.
Where is that?
My lord, kindly turns to my lord.
No, you have raised this point before the appellate authority.
Yes,
Show me that
yes,
and how it has been dealt.
my lord, my appeal, my lord would find. It's at page 38, annexure P8,
38.
my lord.
This is the appeal petition. No, show me from the appellate order that you have raised this point before the appellate authority and how it has been dealt with.
Just 1 second. My lord, kindly see 46 last paragraph, 46 last paragraph.
Yes.
Whereas in compliance to the direction of the Honorable Court, Sri Firdaus Ali had been given opportunity of being heard. 46 last paragraph.
Yes, yes.
On 10/6/2022, during the personal hearing, all the facts of the case were explained, as well as the documents related to case were also shown to him.
So inspection was given.
No, Lord. Their orders, files would indicate, inspection is not so simple. Lord, their order sheet would indicate that the documents was placed to be, I inspected, I put my endorsement. Let them show the file. They have said in the order. For the first time, I've come to know that they have relied this fact to discard my, let them show with the other material, Lordship.
Show me from your pleadings that you have,
Yes, my lord.
you are not given.
Just 1 second. Page 8, paragraph 15, my lord. Just 1 second. My lord, page 9, second, it's 15 Roman 1, 2, my lord.
Yes.
That respond number 3 before passing the impugned order did not allow the writ petitioner to inspect the record, relevant record, as well as the adverse report of Deputy Superintendent of Traffic, including alleged report dated 25/2/2021 of Deputy Superintendent of Police Traffic. So I've said so that inspection was also not allowed. Hard to say, my lordship, the copy was
Where
supplied.
is the order of the original authority after
Yes,
remand?
I'll show you. It's at page. Starts at page, my lord, 33. Annexure P7.
Yes. Did you file a written version?
Lord, this the memo of appeal, because I have buttressed my grounds of appeal before.
No, at page 36,
My lord.
it says he was given another opportunity, if I notice, to submit his written version.
My lord,
If any, submitted his written version dated 4th of July. Show me that.
it would come into play only when the reports are given to me, lordship. I
No, no,
cannot.
show me your written representation.
Lord, this
It
would
says
not
you have
come-
filed your written representation
Just
dated
1
4th
second.
of July, 2022.
No, written version has not been, because I've been asking the authority to give the report. Only if the report is given to me, I can deal with it in my written notes of argument. Since that was not given to me, chance was not given, inspection was not allowed, I had no opportunity because there's no occasion to file, my lord. The writ court in the first round has clearly held, you submit the report, I will deal with it. The petitioner has a right to deal with it. I will controvert those reports, my lordship, because those reports goes to the very root of the matter. That was the foundation of passing the impugned orders.
Yes. Where are those reports?
Reports, my lord, today on first date, my lord.
Yes.
And will be allowed to file my affidavit in opposition.
Not affidavit in opposition, bring those reports tomorrow.
Yeah. My lord.
Tomorrow or fifth.
On fifth, my lord.
Yes. So, Mr. Japal, is it your positive case that at no point of time your licenses were suspended?
It was suspended, I do admit, my lord. But I say the harsh step of cancelling cannot be done.
Mr. Japal, the reports is with regard to suspension for 3 months.
3 months.
So if you admit that, where is the use of
No, but
getting these?
but the thing is, my lord, that suspension was also based on certain material.
But you are not challenging. You have
I've
not
challenged it.
No, Mr. Japal.
Well, I've challenged it.
Suspension you have challenged.
No, see, because suspension
Suspension of 3 months.
culminated in final order being passed by the licensing authority, my lord.
Initially, no, there are two different things. One is suspension
My
for
lord.
3 months
My lord.
with regard to the two-wheeler.
My lord.
Are you disputing that fact?
No, I don't dispute it. I don't
So-
dispute.
so-
I don't dispute it.
So you don't dispute.
No, my lord.
And you have also not challenged that suspension.
No,
And that 3 months period have expired.
expired.
So that suspension was lifted.
No, it followed by an order
That
of.
was only for 3 months.
The license was cancelled finally.
No.
Suspension was
As I find from this, there were two violations.
My lord.
One was on an earlier occasion, which reports you have paid for, and on
Was
the
not
earlier
given.
occasion,
Not
that was not given.
My lord.
That is with regard to an earlier violation.
My lord.
Now the cancellation is with regard to a subsequent violation.
My lord.
So these are the two things.
Two things, my
So
lord.
what happened to the earlier suspension? Earlier suspension for 3 months, that had already time expired,
Yes, my
nothing.
lord. Yes, my lord.
So you are also not disputing.
No, I'm
that.
not disputing.
If you are not disputing that, so that was a fact.
My lord.
The allegation as it appears from these orders is that this fact you have suppressed and you have driven up bars of the authorities without intimating them that your license was
But
suspended.
for that,
If that fact is admitted, Mr.
But my
Jaipal,
lord,
what is
but
the
my lord,
use?
But for that cause, I've been terminated from the service. There is a legal proceeding pending
That is
as
with
against.
regard to the suppression.
Yes,
Suppression.
My lord.
That is the other part.
my lord.
Suppression. But the fact remains that during that period of suspension, you have driven those bars.
No.
Yes.
This was based on
That is the finding.
but this was based on an adverse material. That's my point. This the
Adverse
authority.
material is that is with regard to 3 months suspension.
No, even for all, my lord. No, I will take my lord to the impugner against once again at the cost of
Right.
reputation.
So you bring those reports
Fine.
as adverse reports. What are those adverse reports, Mr. Jaipal? Kindly
My
indicate.
lord, I'll give the exact
Yes.
particulars and detail which they have mentioned in the impugn order.
Yes.
My lord would find it at page
What are the adverse reports you want?
page 45, third paragraph. Page 45, third paragraph. It's a
This
letter
is,
dated
the report, letter dated 25th of February.
of Deputy Superintendent of Police Traffic.
Yes, this
Yes,
is
ma'am.
one.
Yeah.
There's
Another
one more, there is no description given at page 46 at the top.
page
From the
46.
report of Deputy SP, there's no details and particulars mentioned, but these two reports were relied as against me to take an adverse decision.
So these are the two
Two
reports.
reports.
Ashun. By drawing the attention of the court to the office order number 2669, dated 18th of July 2023, 2669 dated 18th of July 2023, passed by the Secretary within bracket Transport, Andaman and Nicobar Administration, Directorate of Transport, comma, Mr. Jaipal, Honorary Advocate, appearing for the petitioner, submits that the reports as indicated in that the report of the report of Deputy Superintendent within bracket Traffic, wide letter dated 25/2/2021, with regard to alleged suspension of the license of the petitioner and the report at page 46 and the report at the first paragraph and the report indicated report of the deputy superintendent within bracket traffic of traffic within bracket traffic as indicated in the first paragraph of page 46 of the writ petition was not allowed to be inspected by the petitioner in spite of a specific direction in that regard by a coordinate bench of this
My
school.
lord.
By a coordinate bench, full stop.
I think this is.
By a
the same
coordinate
report.
bench.
This is the same report, 25/2/2021, showing.
All right, if it is same, you say
cases of
same.
violations.
I
This
have
is
mentioned,
Same report of divisive traffic that it was
according to
observed
Mr. Jaipal, these are the two
that
reports.
he was
I have
disqualified.
mentioned the paragraphs. If it
from
is
driving.
same, you say
The
same.
suspension of driving license.
The learned paragraph, the
Same.
learned advocate appearing for the respondent administration submits that an opportunity was given to the petitioner to inspect those documents. Full stop. This court directs the respondent authority to produce the copies of the adverse reports against the petitioner as indicated in the office order number 2669 on 2669 on the next date of hearing. Full stop. List this matter on 5th of February 2024.
I am grateful.
Yes, next.
My lord, in this matter, I am appearing for writ petitioner. My lord, the writ petitioner has directed me to withdraw the writ petition, my lord.
And I'm appealing for officer as per
He has
one, two,
given me
three.
a
ma'am.
written instruction.
Oh,
Yes. So I am withdrawing.
where is the order of the Supreme Court?
My lord, I am having, but it's the written communication has been given to me.
Give the written commissions to save yourself from your client. The learned advocate for the petitioner submits that his client has instructed him in writing not to proceed with this writ petition any further. Full stop. The written instruction dated 31st of January 2024 addressed to the learned advocate of the petitioner is taken on record. In view of the submission of the learned advocate for the petitioner, the writ petition stands dismissed as not pressed.
Oblige, my lord.
You know, so I'm filing my Vakalapa for the private respondents.
You are for the private respondent. So now why are you, this is the other part. This was the legal part. It's okay. But you are the daughter and the son-in-law. Why are you quarreling with your,
Your lordship,
sort it out since you are
his
here.
mother is staying there. That
Since-
is the issue. He wants that,
After all, the petitioner is your father.
yes,
After all, the petitioner is your father.
what he wants to do, he
So
wants to
since
evict.
you are the daughter, your client is the
Thing is-
daughter, and Mrs. Nag, since you are the advocate appearing for the daughter, see
Thing is-
that these
Yes, yes,
disputes
your
are
lordship,
sorted
issues
out.
has to be sorted out. Thing-
Legal aspect, yes, I have taken care of the legal aspect. That is the other
Actually,
thing, but
The things are otherwise, your lordship. He wants to evict the mother for the protection of
that
the
is
mother.
that is
They
the
are
other
there.
way around. After all, both one is mother is also yours, father is also yours. Since you are there, sort it out. You being the daughter, you have a much more responsibility
Yes, yes.
to sort out these differences. Sort it out.
Sure, sure. Your lordship. Oblige.
Oblige, my lord.
Yes.
My lord, I am for
Well,
the
we are
writ petition.
happy to, my lord, submit, my lord, that because of your lordships, my lords, being in session of the matter, my lords, the demolition order, execution or demolition order, my lord, the order has been passed. I'm just giving the order. my
Which?
lord. This one.
Oh, this order,
Yes, my lord
demolition
had-
order has been passed.
Yes, my lord, but with
Mr.
execution,
Chakraborty,
order,
that is,
because of your
that
lordship.
is, but why?
My lord, the
Took more than 2 years time to sign this order.
My lord, actually, my lord, the chairperson is an elected representative, my lord.
Yes,
So
but
because
for
of
2
that,
years,
they
are you
don't sign.
suggesting that for 2 years, the elected representative was not available?
My lord, what they are very hesitant to sign because it's a very unpopular move, my lord. That is why what happens is the secretary signs, but they do not, because
Mr.
my lord,
Chakravarti,
demolition, my lord,
popular or unpopular, since an order has been passed
lord.
by your authority,
my lord.
so you have to
Yes, yes, my lord.
implement your own order.
The administration did its part, my lord, but because the chairperson is elected, they usually do not sign the execution orders, my lord. It changes.
How
the-
soon it will be executed?
My lord,
Mr.
this is the final order, my lord. This is by.
No, this is the final order of execution. When it will be actually
By 20th,
executed,
it has to
that
be-
is the more important
But
part.
the order says, my lord, by 20th, that much time has to be given, my lord. So
20th of February.
Yes. 20 तारीख को भी लिखा
Have
है।
you, Mr. Chakravarti, have you given him a copy of
No,
this
I-
order?
he was-
You give him a copy of this order? So I'm disposing of
Department
recording
of-
this.
Yes,
Final order has been passed.
Thank you, Mr. Chakravarti, for
It's
this.
only because of your lordship's intervention.
But Mr. Chakravarti, since an writ petition has been passed, these observations were made, this order was passed. But
Yes.
from 2019, why the person will be compelled, since it's your own order? You have a duty to implement that. Why a person shall file a writ petition for this?
My lord, very unfortunate.
I could understand, yes, you have said no, nothing doing, and he has approached. You yourself have said it is an illegal and
My lord.
unauthorized construction, even
My
then you
lord.
are not. Uh, Mr. Chakravarti Lanet, na, তার আগে লিখুন। The writ petitioner has prayed for a direction upon the Port Blair Municipal Council to execute the order number 7995 dated 29th of November 2019. First up. Paragraph. When the writ petition was taken up for hearing on January 31, 2024, a submission was made by the learned advocate representing the respondent numbers 1 and 2 that though the superintendent engineer municipal council has passed a provisional, provisional order is 6952.
yes, my lord. Demolition order had earlier also been passed.
No,
The
no, no.
order
Where is
which
the, sorry. 7995.
Reasonable.
এক মিনিট। না, কি বললাম? That, no, though the superintendent, though the secretary municipal council has passed the order dated 29th of November 2019, but the final order, this is the order of execution.
Yes, why not see the last paragraph of the first page,
Last paragraph, where the chairperson has
given approval.
কি বললাম? Submits that but necessary approval, no, but the final, but necessary approval from the chairperson of the Port Blair Municipal Council is awaited. Full stop. Today, paragraph, today, when the matter is taken up, Mr. Chakravarti, learned advocate representing the Port Blair Municipal Council, submits that the final approval has already been given on 1st of February 2024, wide order number 435. Full stop. A copy of such order filed in court today is taken on record. Full stop. After going through the said order dated 1st of February 2024, it appears that the Secretary, Port Blair Municipal Corporation, has passed an order directing the executive engineer -1 within bracket WKS. WKS is works. WKS bracket close municipal council to demolish the unauthorized building from February 20, 2024 onwards till its completion at the cost and risk of Abdul Sakur is the private respondent. At the cost and risk of the private respondent. Stop. Have you served upon the private respondent?
Yes, my lord, notice has been given.
Yeah, ওটা একদম উপরে লিখে affidavit of service filed in court today. We have not
No,
filed the affidavit of service.
No, no.
File it in course of this day.
Okay.
Otherwise, it will not be signed.
Very.
Affidavit of service. ওটা না করে the learned advocate appearing for the petitioner submits that the respondent number 3 has already been served. First up, the said learned advocate undertakes to file the affidavit of service in course of this day. First up, in spite of service, none appears for the respondent number 3. First up, since the authorities have taken a decision to demolish the unauthorized building from unauthorized as indicated in its order number 435 dated of February 2024, the writ petition stands disposed of, taking note of such fact. There shall be, however, no order as to positive. Mr. Chakraborty, ask your client so that this delay should not be, because a petitioner, a person, litigant had to approach only for this reason. This cost could have been avoided. Yes, call the next matter.
My lord, I am appearing virtually, my lord.
Yes.
For the writ petitioner, my lord, kindly be pleased to see the last order passed by His Lordship Justice Ghosh. The order itself is a speaking order, Lordship, where my submission has been noted, Lordship, on the basis of an illegal encroachment on the part of the respondent number 6, the private respondent from whom I have purchased land, Lordship. And the question of dispute is, Lordship,
Appearing for the respondent.
Private respondent.
For official respondent, I am appearing, my lordship.
Yes.
the encroachment, Lordship, on the approach road, Lordship,
Yes.
which leads to my property. So approach road, which is now been tried to be manipulated by way of filing a rectification application before the concerned Deputy Commissioner, Lordship. On the last occasion, His Lordship directed us to submit such document. I have filed a supplementary affidavit, Lordship. My counterpart, Mr.
Right.
Pardeshia Munda, advocate, on record, he is present. Lordship, the paragraph number 5,
Where
I
is
have
it?
explained it.
Supplementary affidavit is filed today.
It has not yet been filed,
Has been filed, Lord.
but it's not in the record. Where have you filed? In the department?
Department.
Also, it has been filed only today.
Lord-
So I'm making,
Lordship, in the morning.
the learned advocate appearing for the petitioner through virtual mode submits that the supplementary affidavit has been filed today. Oh, it is in the record? No, has been filed today. First up, office. All right. Have you served a copy of the supplementary affidavit?
We have received.
You have received. All right.
Lordship, may I permit to comment?
Yes,
Continue, Lordship.
yes.
Lordship. Now, Lordship, only the crux is that whether there is any manipulation or anything on record visible to your Lordship or not, which has been committed by the respondent number 6, Lordship. Lordship, P2 of my supplementary affidavit.
No,
Is the Lordship.
to you, the respondent number 6 has filed an application for correction of the record of rights.
Lordship.
So
Due to Lordship.
Yes, but no decision has yet been taken. According to you,
No, Lordship.
that plot is recorded in the name of the private respondent. Your approach road, there will be an obstruction.
Lordship.
That be decided by the deputy commissioner. Deputy commissioner.
Lordship, what troubled me to file this writ petition is Lordship, that application has been preferred in the 2023 in the month of July. But
Yes.
Lordship, I have not been served with any notice or I have not been intimated by the concerned authority that
Alright.
such an application has been.
Correcting-
Only Lordship, my humble submission before your Lordship is that a direction be given to the competent authority that nothing be taken place, no rectification or nothing be taken place without hearing me. Till then, no, my approach road should not be hindered, Lordship. That is my humble submission, Lordship, which I am enjoying since last 10 years, Lordship. That should not be encumbered in any manner whatsoever.
Your complaint is at page 31.
Lordship.
Your
I have some.
page 31. And where is the private respondent's application for correction?
Lordship, supplementary affidavit, Lordship, P2.
P2.
Which I have obtained, Lordship. I have filed that the last file, the coordinate bench, Honorable Justice Tirthankar Ghosh
Yes,
has
sir.
been pleased to.
Directing the deputy commissioner to
Lordship.
their application for rectification and your application together upon hearing both of you.
Lordship, any manner I should not be encumbered, Lordship. That is my only way to approach my property, Lordship. That's all, Lordship. Nothing more.
Lordship, in this matter, kindly come to page 32. Lordship,
Yes.
annexure P4, which has been filed by them.
Yes,
I'm sorry, Lordship, page number 34.
34, yes.
34. Upon their request, the deputy commissioner was directed to do the demarcation of the land
Yes.
in which the approach road has been asked. So the page 34 shows what was the finding of the demarcation.
Yes.
In page 34, it shows that an area of 206 square meter of land found under the physical occupation of Shri Rajesh case, who is the writ petitioner here.
Yes.
He purchased the land 168 square meter, Lordship.
Yes.
And upon demarcation, it has been found that he is in occupation of
Excess land.
land.
Yes.
Excess land. One thing, Lordship. Another thing which I want to point here is in the local legislation.
Yes.
In the local legislation, if there is
What is your name? Madan Mohan Singh.
Madan Mohan Singh.
Yes.
Now, as per the local legislation, Lordship, if any obstruction is done, then the power lies with the Tehsildar.
Yes.
I want to show the regulation to Lordship.
Yes. Yes.
Regulation 104 LR.
Yes.
Now, if regulation 104, Lordship. Now, Lordship, if the writ petitioner has any grievance, he should have made an application before the appropriate authority. And in this case, the appropriate authority is the Tehsildar. Now, without 104, Lordship.
Yes.
Now, without using that thing, they have come before the writ court, Lordship. If this practice is is appreciated, then the writ court will be burdened with all this, Lordship. (104), Lordship.
Yes, yes.
Regulation.
So according to you, the deputy commissioner cannot decide that fact.
Yes, Lordship, because the practical thing, the Tehsildar has the idea. And another thing, if they are appearing before the writ court, their hand should be clean. As per the demarcation I have shown, they are already in excess land of somebody else, Lordship. So the appropriate authority is the Tehsildar. I am
Yes.
not telling the grievance is not there. What I am
Yes.
telling is it should be before the appropriate authority.
Yes, sir, the appropriate authority is the Tehsildar. Why are you not approaching the Tehsildar?
Lordship, I differ with the submission of my learned friend. They have approached before the deputy commissioner.
No,
The
they,
document shows that for
they-
rectification, and they are submitting, Lordship. Kindly appreciate this.
kindly hear me. They have approached for correction of the record of rights. They have
Lordship,
correction of the record of rights. That is one.
Lordship,
And you say is encroachment, removal of encroachment.
Lordship, they are relying on the report submitted
I'm not
by
on-
the by the authority.
Sir, I am not on the report. Only thing
Lordship,
you want, according to you, you are alleging that someone is
no,
on your property.
Lordship, no third party interest be created. No encumbrances on my peaceful free ingress and ingress be done, Lordship. That is my humble submission, Lordship. Now, if they rectify it by way of a manipulation,
Sir, kindly
this
hear,
can,
allegation
Lordship,
is encroaching upon your property. So you want removal of encroachment.
Lordship, I am apprehending that they don't encroach my property by way of creating a third party interest.
No, third party interest. What is
At present, there is no encroachment, Lordship. At present, there is no encroachment. Only my humble submission is, Lordship, the rectification they have sought for be not heard in absence of me. Notice be issued, both party be heard, Lordship. Then a decision be taken so that my approach road should not be hindered or encumbered by any manner whatsoever, Lordship. This is my humble submission, Lordship.
I'm not denying this. What I'm telling is, first of all, no action.
I don't think my learned friend will deny this fact, or there will be any dispute in this regard if a person claims that his approach road should not be encumbered in any manner whatsoever, on the ground that his client have made an application for rectification. And if that be heard in my presence,
No,
then
but
where is the difficulty?
his application is for correction of the record of rights. His application is for correction of record of rights only.
Lordship, now the measurement, Lordship, he is trying to
No,
create
not
an encumbrance.
So according
In
to
my
annexure P2 in the supplementary affidavit, that is with regard to rectification in the record of rights.
Lordship,
So-
absolutely, Lordship.
So,
Now, Lordship, in the garb of this rectification, if he manipulates, because if I am not been taken into account in this hearing or in this proceeding, he can make a complication, Lordship.
one aspect. And what is
Lordship,
your, where is your complaint? What is the nature of your complaint?
Lordship,
That is insufficient sparing of footpath space. That is nothing but encroachment.
Lordship.
Encroachment, how can the deputy commissioner decide this?
Lordship, during the
Decide this complaint of encroachment.
Lordship, they are trying to encroach, and they are trying parallelly. They want to rectify in the garb of rectification, Lordship.
You approach before the Tehsildar. You approach before the Tehsildar. And yes.
Lordship, such liberty be granted to me, Lordship, and Lordship, the deputy commissioner's rectification procedure shall not be conducted in my absence, Lordship. Kindly give this much.
What will
Because
not?
Lordship, during this rectification procedure, Lordship, because there is physical inspection is required, whether the amount of land they are showing they are portraying before the deputy commissioner. This much, Lordship, I only beseech before Lordship this much relief, so that my approach to it should not be hindered in any manner, or no encumbrance be committed, Lordship. Only this much.
Lordship, for the record correction.
I won't stand in the way of rectification of the respondent number 6. If my approach to it is not been encumbered,
The
I won't stand on the way, Lordship. Only my humble submission, I beseech before Lordship, my approach to it should not be disturbed, so that, because that is the only road from which I can make my ingress and egress to my property.
the writ petitioner has prayed for issuance of a mandamus restraining the private respondent from transferring, alienating, alienating and or delivering his right, title and interest of 23 square meters of land of survey number 1074/1 as house site situated at village Jangli Ghat under Port Blair Tehsil to any third party. Without providing for adequate space for footpath. Full stop. A writ of mandamus cannot be issued against a private party. Full stop. At this juncture, the learned advocate for the petitioner submits that the private respondent has filed an application for rectification of the record of rights in respect of survey number 245/3 corresponding with survey number 1074/1. No, he submits that the private respondent has applied for rectification of the record of rights. No, in respect of survey number 1074/1 as in the record of rights, the area of such plot was mentioned as 0.0023 square meters instead of 0.0169 hectares. Full stop. The learned advocate for the petitioner submits that the petitioner apprehends that the property of the petitioner may be encroached in the garb of correction of, record of rights. Full stop. In case the petitioner apprehends that in case Regulation 104 of the Andaman and Nicobar Islands Land Revenue and Land Reforms Regulations 1966 empowers the concerned Tehsildar to remove any obstacle or encroachment upon any portion of the property. Full stop. In case the petitioner apprehends that a portion of his property. No, apprehensions that any portion of the property has been may be encroached upon, comma, it will be open to the petitioner to approach the appropriate authority with a representation. And if such, if such a representation is made, comma, the concerned authority shall consider and dispose of the same in accordance with law after hearing the respective parties whose interests are likely to be affected thereby. Full stop. With the above observations, the writ petition stands disposed of. Yes.
Lordship, only Lordship, one line, Lordship.
Yes.
During the course of this rectification, Lordship, I may be given an opportunity, Lordship, because I have purchased this land from respondent number 6.
Be open to the Deputy Commissioner, South Andaman District, Port Blair, to hear any of the necessary parties at the time of considering the application for rectification, of the record of rights submitted by the private respondent hearing. If you are interested parties, he will give. Because this.
I'm so grateful, Lordship. I'm so grateful for your Lordship's exhaustive order, Lordship, and direction. I'm grateful, Lordship. I'm deeply obliged.
Yes, next.
Lordship, I am in this matter as well, in item number 8, Lordship. Can it be, my Lord, be fixed on 7th, Lordship?
What is this matter?
Lordship, this matter is, I've not yet briefed, Lordship, by my learned junior friend, Lordship.
Yes.
Kindly be pleased to fix it on 7th, Lordship, kindly.
7th?
On 7th, Lordship, if your Lordship permits.
For the petitioner, list this matter on 7th of February. Yes, next.
I am grateful, Lordship. Great.
Item 10, CO4 of 2024.
Mr. Jaipal is appearing, is on like board number, just not today.
Not today. Next.
Item 11,
This
SS7
is not today.
Which item?
11, item number.
Why? What is this application for? Dekhi, file. Give me the file. You are for?
Presenting on behalf of Mr. KMB. नहीं है
Have you served a copy of this application?
So, for applicant Mr. Ajay Mandal is appearing. Yeah, for the response. हाँ तो अपील किसका है आप लोग में
You are for the appellant or respondent?
रिस्पोंडेंट
Respondent. You are for the appellant? Yes, what do you want?
fine
Yes.
just not today Mila tomorrow
Not today, next. Ajay, order record kori as prayed for by the learned advocate for the petitioner, in Can 1 of 2023. Hearing of the matter stands adjourned for the day. Yes, next. Yes.
Lord, I am ready because despite of an order in my favor, we are unable to get the fruit of the order, man.
Yes, Mr. Chakravarti, you have difficulty today.
Table court, my lord, the lower court record, my lord, I don't know if it's come. NCR has to.
What is the issue? What is the order under challenge? What is the award under challenge?
Award, my lord, they work for a considerable period without following the mandate of section 25 FB.
Retrenchment
Retrenchment, we are saying
Labor
that they-
without compensation.
No, my lord, I would be the last person in the cadre if they are retrenching me from service. And secondly, that ought to be, if I complete 240 days in terms of section 25B, then they have to mandatorily follow section 25F. That was not
Without compensation.
Yes, my lord.
our contention,
No, yes, my lord.
my
Now, my
appeal,
lord,
our
after a full dress trial, Labour Court arrived to a finding that it was a illegal term.
no, our
But the
contention.
authority, it is the authority's writ
Our,
petition.
our contention is that first, that they were contractual workers not covered under the Industrial Disputes Act. Secondly, they do not perform for 240 days. So if assuming that the first is not accepted, then they did not perform for 240 days. So well as all those evidence has
So
to
you
be
have two
seen,
limbs of submission.
my lord.
If the first goes, then second.
Yes, then second. Now, my lord, the evidence has to be seen, my lord. I don't know if the lower court record has come, it's a very old matter.
Local records have come.
But paper book, I think, has to be filed, my lord.
No, my
Otherwise, how
my
will we
lord,
present
my
the
lord,
case?
the
But,
interference in an award passed by the Labour Court, which is not an appealable order, is only when the award of the Labour Court is perverse, my lord.
No, but 2018, this has
that
been
is
filed.
clear.
Court has entertained in 2018, my lord. Now it is in the hearing list. So, my lords, we have to assist your lordship, my lord. At least the paper book, I think the lower court proceeds. Otherwise, if we refer, my lords, how will we?
It's he's not getting anything.
Let him file the paper book, my lord. He
Why
will,
should
he will
I
more
file? I am a labor.
The cost part, Mr. Chakraborty, kindly appreciate. You are appearing for the administrator.
my lord.
He is a labor, according to you, a contractual labor.
Yes.
My lord.
Who has been retrenched,
Retrench.
not getting any compensation.
But
How
he has,
can you prepare the
he
paper
has,
book?
he has briefed Mr. Kumar. My
No, my lord. I do
He's not-
several pro bono matters, my lord.
So,
Let him file the paper. I can file the paper. I'll file the paper. I'll file the lower court record. I'll file an informal paper book, man. Let it be kept for hearing.
informal paper book will be helpful.
Well,
for,
well.
Otherwise,
Mr. Chakraborty, learned advocate appearing for the administration, volunteers to prepare and
unless will pass
it
direction,
will
my
be a
lord.
difficulty.
Unless I cannot make any concession, my lord, without written
All right.
instruction. Is
Yes,
directed,
yes,
my
yes,
lord.
yes, I follow.
Please.
No, volunteer category. Considering the nature of the category, considering the nature of the dispute involved and the voluminous records, comma, this court directs the, oh, you are the appellate or the writ petitioner.
Yes, yes, my lord. I will.
This court directs, oh, I was thinking in the other way.
No, my
So,
lord. We are it.
This court directs the writ petitioner to prepare an informal paper book. Full stop. Let such informal paper book containing the relevant materials be filed. Yes,
2 weeks, my lord.
within a period of 2 weeks upon serving an advance copy of the same to Mr. Kumar, learned advocate representing copy of the same to Mr. Kumar, learned advocate representing the respondent. List this matter after 2 weeks.
My lord.
List this matter after 2 weeks will be the next.
My lord.
List this matter before the next circuit bench.
My lord. Highly obliged.
Yes, next.
The list have exhausted. This is what I have mentioned in the morning. This can be taken up. The second appeal. This is the one for which I have made the mentioning at the mentioning hour.
Who is your other side?
For the appellate.
Both of you are ready.
My thought I'm coughing, sitting in court.
Other matters concept does
So I-
with this thought, but this matter comes, thought comes. That's the problem. Not 2019 matter. Not. I'm ready with the matter. Very short point.
What is the point?
Suits were filed before the trial court. In my suit, I have sought a declaration of title based on a gift deed, registered deed. Plaintiff, I'm the plaintiff.
Declaration of title based on a gift deed.
Registered gift deed. They filed.
What is the relation between the
Nobody.
parties?
They are nowhere related. But the
His
concept.
client gifted the property to you.
No. The property which I have acquired is from one Mishra. Lordship, they say that the same gentleman, after that Mishra who had gifted the
He has
property,
also transferred to
will, based on, they claim title based on will.
based on will.
Title
And when the person died,
Lordship, he died after the suite land was gifted to me, and during the pendency of the suit, he died. He was an original defendant in my suit. Lordship, both the suit was dismissed by a common judgment by the trial court.
no, Mishra was the original defendant in your suit.
Yes.
Because Mishra also disputed that he has gifted the property.
No. There's no dispute. But since when I applied for Tahsildar for mutation based on my gift deed, the problem started. So I filed the suit. Because title was with me, I sought for declaration. Now, both the suit was dismissed by a common judgment by the trial court.
No, both the suits means your suit was dismissed.
And his suit also dismissed.
Whose suit?
The suit filed by Khan Sahib's client seeking declaration of title based on will of the self.
Based on will. From Mishra. So both of you are claiming from Mr. Mishra.
Yes, absolutely. The suit was dismissed.
So your suit was dismissed, their suit was also dismissed.
By common judgment by the trial court.
All right.
Lordship, in this trial, before the trial, they sought for a comparison of the signature appearing in the gift deed of Mishra, because they say that since the Mishra is no more, that was not executed by Mishra. Lordship, an expert body was GQD was appointed, a report was submitted, and he was cross-examined also with reference to the report of GQD. The trial court ultimately, while deciding certain issues, while dismissing my suit, held that the gift deed is a valid deed. It was executed by Shiv Shankar Mishra because I have examined the attesting witness to those deeds.
But why the suit was dismissed?
On a hyper-technical ground. I'll show that now.
What is the ground?
I'll just show just 1 second. The ground was, I'll just show. The trial court held.
And what did the appeal court do?
Appeal court, Lordship, allowed my suit, decreed my suit, and dismissed their appeal.
All right.
Lordship, against which these two appeals by them.
By them.
One is against judgment of affirmation, one is against judgment
of the respondent.
Respondent both the appeal. Their point.
What is the substantial?
Yes, paperbook. They say that during the pendency of the appeal, because both the appeal and cross appeal was taken up together, analogous hearing.
Yes, has to be.
In their appeal, they substituted one party.
Where is the substantial question of law? Paperbook, which page?
My lordship would find at.
Yes, I've got 318.
My lord. See one.
Mr. Jaipal, who is the respondent number 6? Respondent heirs were not substituted.
No, Lord. There are no. I am coming to that. In their appeal, the LRs were substituted. My point is, if both the appeals are taken up together, there are judgment of Supreme Court. Lordship.
Let me clear myself on facts. There were 2 appeals.
My lord.
Because both of your suits were
dismissed. Yes, my lord.
So, who is the respondent number 6?
In my appeal, I'll just give the name.
SAT 1 of 2019.
One of Reshma was the respondent number 6.
Yes.
Who was she?
She was a party in the.
She was respondent in their appeal. And appellant in my.
She was the respondent in your appeal.
Yes.
And she was
which got decreed.
Yes.
Which got decreed.
So, respondent number 6. So, this decree was against a dead person.
No.
Yes, Lord.
In their appeal, the same lady.
I'm considering your appeal only.
My lord.
So, your appeal was decreed against a dead person.
No, my lord. I'm coming to that. Even if it is a dead person, I understand.
Let me
My
clear
lord,
the
dead
facts. I
person.
will come to their appeal.
Dead person.
Let me consider this
Yes,
separately.
Dead person.
Your appeal
My lord.
was decreed against a dead person.
My lord.
So your submission is that since the years were present in his appeal and these 2 appeals were heard analogously.
Yes, my substitution is not a fatal. This is one aspect. Secondly, already on record, in their appeal, as I've said, Lordship, his LRs are there. So there are judgments of this there. Some of them have been left.
Oh, some of the heirs are there.
Yes, even there is a judgment which say I brought that judgment.
So according to you, there is no case of abatement.
Absolutely. That's my point.
Some of the heirs are already.
Yes.
So you are sure on facts that some of the heirs.
Yes, my lord. Yes.
No, there was no.
But it
no
says
other legal
without
of the respondent.
substituting the legal heirs of the respondent number
No,
6.
this is what is substantial, not the,
No, that is the substantial question of
this
law.
needs to be gone into.
Yes, so according to you, some of the heirs
Yes,
were
yes,
already
it's
on
record.
record.
Yes.
So Mr. Jaipal, do one thing, prepare a genealogical chart with regard
My
to
lord,
this.
I have prepared a short notes argument with judgment.
Short notes will come
My
after
lord,
that.
my lord.
First, prepare a genealogical table
Chronological dates
with
events
regard
first.
to this, because according to you, these legal heirs were already on
My
record.
lord,
No,
So
there
you have
was.
to indicate
my lord,
in that chart
my lord,
who are the heirs
Names.
and who were parties
my lord,
how.
my lord,
Indicate, prepare a chart in
My
that
lord,
line.
my lord.
Respondent number 6 heirs was 2 only. I substituted them, they have not substituted. And order, I have brought the order of the trial appeal
So
court.
Mr. Jaipal,
which reflects
according
it.
to you, how many heirs did the respondent number 6 have?
But two are the two left, no, sir.
He says there were only two legal
No,
heirs.
no.
Yes.
I'll prepare the chart, but kindly see the
Prepare
chart.
a chart. So exchange the chart if you want to
This,
prepare a
this
chart.
would be a worse situation. The first point would be, because both the appeal are taken up analogously, in their appeal, they have substituted. Lordship, on the ground of non-substitution of LS in my appeal, Lordship, my appeal will not be abated. My point is
Mr.
that.
Jaipal, do you have an authority?
I'm
to
having,
support of yours?
yes, absolutely.
Two
Yes,
separate
yes,
orders
I'm absolutely on
maintained.
that. Lord, his
If,
judgment, yes, absolutely.
if the appeals are heard analogously,
Yes.
if in one of the appeals
Yes.
substitution is not
Yes.
made,
Jairam, Lordship, Jairam Reddy and other versus Revenue Divisional Forest Officer, 1979, 3 SCC 578. Aptly on the point. Aptly on the point. Aptly on the point. I'm on that.
how much time it will take?
No, I will not take time, provided Khan Sahib completes, because his appeal.
No. Not taking time means I'm not asking you about adjournment. How much time it will take?
No, sir, and that's what I'm saying. Khan Sahib completes within 15 to 20 minutes. I will take 5 minutes. I will
No,
just
yes, I
rely
will
upon the
take-
How much
citation.
time it will take?
Your lordship, I will take.
These are the two issues, substantial questions of
No,
law.
first point is, your lordship.
Yes. First
about the
point
death.
is discarding the evidence of handwriting expert.
Yes, your lordship.
So handwriting expert with regard to the gift deed
Gift deed.
executed in favor of Mr. Jaipal's client.
Yes.
So what is the effect of that handwriting expert? That is to be considered only with regard to that.
Yes, your
The
lordship.
entire evidence and other things need not be considered.
Only
as
the evidence
secondary.
of that.
And the other is the effect of non-substitution.
Yes.
That is the point of law.
First, this point is to be decided whether the appeal pending before the was abated or not against the person responding.
I will decide it as a whole,
As a-
not piecemeal. If it goes in its entirety.
Your lordship, it will go because it is a root of the
That-
matter.
That Mr. Jaipal is taking risk.
Is a root of the matter.
Yes,
I'm
yes,
taking the
yes.
risk, Lordship.
But it
Kindly-
cannot be decided piecemeal.
Kindly see.
You have to make submissions on these two substantial questions of law, and it will be decided once for all.
Your lordship, I have to place the.
If you
lower court-
succeed in showing that yes, his
Order sheet.
appeal has abated,
Yes,
abated.
yes, your lord. If it is abated, there is no question to go into the merit of the appeal, your lord. That is
No,
my
no, the other
submission.
stuff, you prepare yourself on both because I will not take these issues in piecemeal. You have to make your submissions as a whole.
As a whole, next week.
I
it
will
be
decide
fixed, your lord.
which issue to be taken up first.
Yes, yes, your lord.
That I will decide when.
Monday.
As jointly paid by the learned advocates for the parties, list this matter on February 5, 2024, under the heading hearing. Yes.
Obliged.
Any other matter? No. All right.
Matters are there, my lord. Other side is not there.
With one.
Matters are there, but other side is not there.
That is,
My humble prayer is that item number 57 may be updated. It's urgent matter.
upgradation will not help. Both sides come, yes. I've said, if both sides come, I will take up. Upgradation, neither here nor there.
Here the matter, the other side will not come. Because the matter is absolutely in my favor.
Then I have
so
to
that is the
proceed
reason.
serially, because these are the hearing matters, I cannot jump the queue. Hearing matters, upgradation may be a
Thing
difficult.
is that there are several order passed with honorable court, but the orders have not been
Then you have to
implemented.
wait for your chance, because I have to call the entire list. Cannot be taken up in that way, because I cannot jump the queue in the, so far as the hearing matters are concerned.
What